So here again, I'm working on a strong assumption that all of you have been bombarded by various AI posts, guidelines, cheat sheets, etc. What often comes in such posts, guidelines, or cheat sheets is the AI Act's risk pyramid. What is often, though ever less so, the case with this pyramid is that it has a four-part structure: prohibited systems, high-risk systems, limited risk systems, and low-risk AI systems. This is unfortunately wrong, as only two of those actually exist in the AI Act, and even for the purposes of completeness, one should only ever be talking about three, namely prohibited AI practices explicitly listed in Article 5, high-risk AI systems, which we already somewhat tackled in one of our sparks and which are basically determined by Article 6 in combination with Annex 1 and 3, and then the third, implicit category, which basically entails everything not falling under the first two. Okay, so where does the fourth part pyramid then come from, or why is it being shared on the internet? Well, the direct blame is actually on the commission that first published the graphic, and well, everyone kind of just took it over as, it came from the commission after all. And this pyramid then has, this special category between the high risk and the low risk one under the title limited risk. And how do I, but also increasingly many people online, then dare say this is false? Well, because this category, or rather the systems theoretically falling in it, will in certain cases be high risk, while in other they will be low risk. To be more specific, this category is a direct consequence of the transparency obligations listed in Article 50, which mentions them as systems performing emotion recognition, which then has to be explicitly disclosed to affected persons, and so do any interactive AI systems or contents produced by generative AI systems. And so, in case of emotion recognition AIs, this will be in the high-risk category, meaning all the other AI Act requirements applicable plus the extra transparency provision. In terms of interactive and generative AI systems, however, only the additional transparency and, well, the generative or rather general purpose AI provisions are applicable. At least that is until I use this system for a high-risk purpose. So as you can see, there is no limited risk category. There are only additional transparency obligations imposed on certain types of AI systems. Or at best, this category could be described as a very fluctuating and fluid subcategory. I personally, however, do not see this as of great value, but as a rather confusing thing. Plus, this category is again not explicitly mentioned in the AI Act, which only adds to the confusion. So can we all agree to just have the three and leave transparency obligations on the side for the moment? I really hope we can.